Okay.
Um, so good morning, everyone. Thank you for joining us. We do have present with us Craig Feister with the Federal Motor Carrier Safety Administration. And Craig, I'll let you go ahead and take the floor.
All right. Good morning, everyone. Thank you, Christina. Yeah, I was just talking to Christina early about your organization a little bit, and I appreciate the opportunity to come in and talk to you today. And hopefully, over the next hour, you'll get a little better idea of some of the regulations that apply when we're talking about drug and alcohol programs. So that is our goal today, is to give you all just a good overview of the controlled substances and alcohol use testing regulations. And again, that's a long title where it's just the drug and alcohol testing requirements that apply. And we're going to focus on it sort of from the management level today, not really from the driver level, but from things that you all as management and those who work in the offices and in the background need to know, because typically a lot of the requirements fall upon you all to make sure that this stuff is managed and monitored and organized properly. So, and I guess with questions, if you have any, just put them in the chat, and Christina she'll monitor them. We'll answer those as we go. So I'm going to start out with some critical information. What we're going to talk about today applies to employers. So you all as employers must ensure that all these regulations are followed by the drivers. Now, I know we have drivers also, and they have a role in this, but the regulations pretty much place the burden of compliance on the employer, not necessarily on the driver. In a lot of cases, there's dual requirements. Obviously, drivers have to comply and do certain things, but you as the employer must make sure that they know what they're supposed to be doing, and that you have created that environment where you set the standard. So with saying that, any of the violations that we find in the drug and alcohol program, though, even though it might have been committed by a driver, that you as the employer are responsible for those violations. So I always like just to talk about that. Sometimes we've run into employers that sort of require their drivers to comply and understand all this kind of stuff, and that's okay, but you cannot pass that responsibility off to your employees. It's you as the employer, like I said before, must set the standard. So who do these drug and alcohol regulations apply to on here? And we need to be very specific when we're talking about the DOT drug and alcohol testing regulations. There's a lot of other authorities out there for drug and alcohol testing. You can, there's the employer, drug-free workplace programs and things like that. But we are going to talk very specifically about the DOT drug and alcohol testing requirements that apply to commercial motor vehicle drivers. And we need to make sure that any employee who falls subject to these regulations is kept in a separate pool from others that are drug and alcohol tested. This is very specific to commercial motor vehicle drivers. So who is subject? So if you're an employer who has drivers who operate commercial motor vehicles, that's what CMVs are, commercial motor vehicles in the US, and are subject to the commercial driver's license requirements, then your company must have a compliant drug and alcohol program. So again, if you have drivers who have a commercial driver's license, and the reason they have that license is that you have trucks that require it, that they operate, then these rules apply. Okay, if you don't have drivers or trucks that meet those requirements, then you can still drug and alcohol test, but you are not doing it under the authority of these regulations. You're doing it some other authority or some other policy that you have as a company. Now, we do mention here, and this really doesn't apply, that an employer who employs themselves. So in the trucking world, an owner operator, they own their own truck and they employ themselves. There is a requirement that they have to be in a consortium, and a consortium is nothing more than a group of employers and employees that sort of pool together to accomplish drug and alcohol testing. So they have to be in a consortium. But if you're an employer, uh, that you own your own company and you have, some trucks, 4 or 5 or 6 trucks or whatever it might be on that, then you do not have to be in a consortium. But we'll talk about that a little bit more. So what are the prohibitions and the regulations? Pretty straightforward. That you cannot drive with an alcohol concentration above the legal limit set by FMCSA. Okay. Obviously, employees, drivers in this case, cannot use alcohol or prohibited drugs while they're on duty, before they come on duty, or following an accident. So those are sort of the general prohibitions. Nothing really surprising there. Everybody sort of understands that. So what are your responsibilities if somebody does one of those things we just talked about earlier, one of those prohibitions? Your responsibility is to immediately remove that employee from that safety sensitive function. And we call it safety sensitive function because there is non-driving activities that fall into the safety sensitive functions. So, let's say you have a driver who not only drives, but they also help maintain that vehicle. Well, if they were to test positive for marijuana, let's say, then they could not only drive, but they couldn't work on that vehicle for maintenance too. So you have to, if you want to retain them after they test positive, then you would have to put them in a non-safety sensitive function. So keep that in mind on that. But you got to immediately remove that employee from that role, and we're really going to focus on the driver role today. So when you get a verified positive drug test results, or if you get a verified tainted or substitute drug test results or alcohol test greater than 0.04. For commercial vehicle drivers, alcohol 0.04 or higher BAC is considered under the influence. Just like for four-wheel, for passenger car drivers in Virginia, it's 0.08, but we have 0.04. So a higher standard. They're the professional driver. They're in business working for you all. And so we have that higher standard, 0.04. So we will talk a little bit more about these as we go along. There's another term in here you're going to hear me talk about. It's called a substance abuse professional, or SAP for short. And that is a person, just like it says in the slide, that evaluates employees who have violated the DOT drug and alcohol regulation. And then in addition to that, they make recommendations about whatever education, treatment, and follow-up and testing and aftercare that employee who violated DOT drug and alcohol regulation has to comply with. So a driver who tests positive, for a controlled substance, a prohibited controlled substance, or an alcohol test 0.04 or higher, they are referred to this SAP, this substance abuse professional, for this evaluation and treatment.
Craig, we did have one question come in
Yeah,
from the previous
sure.
slide. The question is, what happens if it's only your owners that are drivers before we've been, and she was saying before we've been exempt?
Yeah, no, they were there. There was never an exemption. If you have an owner who is a driver and they have a CDL because they need to operate the truck, then that person is subject to these rules. There are no exemptions for anybody who has a CDL and drives a vehicle where that CDL is required. Drug and alcohol regulations apply. They always have. Yeah, and I think that's a good question. And Christina just mentioned that the drug and alcohol regulations have been in effect in one way, shape, or form since 1989. There's been some tweaks to it over the years, but Congress decided back in the 80s that it was important enough to have this program apply across just across the spectrum. And this, I mentioned employers in there. It is any employer, public sector, private sector. So this applies to government entities too. So I'll mention like the big one in Virginia. We have VDOT. VDOT employs thousands of drivers who have CDLs because they operate a vehicle where a CDL is required. VDOT has a drug and alcohol testing program because they're an employer, so they're subject to the same rules as anybody in your organization or as anybody that does the work that you all do. So no exemptions for anybody. So keep that in mind. It doesn't matter if it's the owner or not. But again, so there's your SAP on that. Now, we do have a one thing I want to point out when we come to what's a consequence for drivers and alcohol use related conduct. Remember I said 0.04 and above is considered a positive alcohol test under the influence at that point. However, let's say the alcohol concentrations 0.02 to 0.039. That is not 0.04 above, so it's not positive, but it is somebody that there is a measurable amount of alcohol in their system, and so they cannot drive for at least 24 hours at that point. So, keep that in mind on that, because, alcohol testing is also part of the program, and you could have a driver who, on the breathalyzer measures, 0.02 to 0.039. That's not positive. So you don't have to immediately remove that person from a safety sensitive function and refer them to the SAP and all that. But you do have to shut that individual down for 24 hours. So if they were tested at 8 a.m. this morning and they were 0.03, that means you could not use them till at least 8 a.m. tomorrow morning because of that alcohol concentration level, but they are not positive. So what are the required tests on here? And make sure you really understand this. There are many other types of tests that are out there, but again, for DOT purposes, for drivers and employers subject to the DOT regulations, these are the different types of tests. And I just list them there, then we're going to drill down, talk a little bit more about each one of them. You have a pre-employment, but that only applies just to the drug test only, not alcohol. On that post-accident, then random, reasonable suspicion, return to duty, and then follow-up testing. So those are the different types of tests that are part of a DOT program. So what is pre-employment testing? That basically says that a driver shall not perform safety sensitive functions, including driving, until a negative test result is received. So you have a person who comes and applies for a job as a driver. They have a CDL because you have a truck where a CDL is required in order to drive it on that. And again, that's any single vehicle or combination of vehicles over 26,000 pounds gross vehicle weight rating, but they have to have that CDL. They're required to operate that vehicle. They have to have a negative, you have to have a negative pre-employment test before you use that person for the first time. So let's say they come in today, you send them to whatever location you've chosen to get that test. It usually takes, a couple days for that test to, go through the process. You cannot use that driver until the MRO, the medical review officer, and we'll talk about that a little bit more, reports to you that that test is negative. All testing is urine specimens too at this point, not hair, not any other way, not blood, all urine testing on that. So don't use a driver until you have that negative drug test result back. And typically that'll be informed to you all through an email, a security email. Sometimes they do it by phone, but typically it's done by email, just so there's a written record of it. Post-accident testing, you all have drivers, they're out there driving all over the place. Unfortunately, getting involved in crashes is something that could happen. We hope it doesn't, on there, but it can happen. So if it does, and your driver with your truck is involved in it, then we do have a requirement for post-accident testing if certain, criteria are met. Now, if there is a fatality in that a crash, a fatality, any fatality, then a drug test, post-accident test must be given. So that's the one where in any fatality, one must be given. Okay, now the others, a bodily injury, and we consider bodily injury where they have to be, transported immediately away from the scene to get medical treatment. So not somebody who, 2 days later, says, hey, my back hurts, my neck hurts, I'm going to go. I think it was that crash. No, that does not mean, that does not meet our criteria for immediate. Somebody where they're immediately transported away from the scene of the crash for medical treatment. So for that category and for disabling damage on there, and disabling damage really is, your vehicle or any other vehicle involved in that crash could not be, could not be driven away, had to be towed away. It was disabled to the point where it was not drivable. So if those two categories, the bodily injury and disabling damage occur, and your driver was issued a citation at the scene, then post-accident testing applies. So if there's a fatality, it applies regardless of whether or not a citation was issued. Okay, so you have to get a post-accident test done then. If a citation is issued and you have bodily injury and disabling damage, then your driver has to be post-accident tested. And again, remember, this is not only your vehicle or your driver, but it's any vehicle or driver involved. So you're sitting at a stoplight somewhere, your driver is in the truck, and somebody rear ends your driver. In that case, your driver was not issued a summons, most likely, because he's hitting the rear. So even though there might have been an injury or disabling damage, no post-accident test is required because your driver was not issued a citation. Now let's reverse that. Let's say the opposite happened. Somebody else is sitting at a stoplight, another car, your driver's distracted for whatever reason, looks up, there's a car stop, hits the brakes, cannot stop, crashes into the rear of that vehicle. The car has now maybe has disabling damage, or maybe the driver was hurt, or your driver was hurt, or your vehicle had disabling damage. Well, since your driver hit that other car in the rear, most likely law enforcement is going to issue your driver a citation, a summons. I know in Virginia, that's pretty much the rule of thumb. They issue that summons. If that's the case, then a post-accident test is required. So, and you have to do that. There's criteria on when it has to be done. So, but it's upon issuance of that citation when those other criteria are met. Random testing. Random testing is sort of the foundational part of this. That is really the big deterrent. Drivers know that, under the random program, they could be, selected for a test at any time. At this current time, the rate is 10% of your number of drivers for alcohol testing and 50% for drug testing. So let's say, and you do random testing quarterly. So let's say in the first quarter, let's just go back to January of this year, the first quarter, January, February, March, let's say you employed 6 drivers. So you would need to have 3 tests done during that first quarter for controlled substances, because that's a 50% rate, and then 10% for so you'd have to do what's 10% of 6? What, 1, right? No, 1. what is it, Christina? What is 10% of 6? To you, 1 point, it's 1 point something, right? So you'd have to do 10% of testing for the drivers on that. So that is your rate. So, you're doing it every quarter, you're spreading it throughout the year, but test at those rates. Now you can test more than that at a higher percentage, but you must do at least 50% for controlled substances and 10% for alcohol on there. That is the minimum that you're required to do. Reasonable suspicion testing. A driver must submit to an alcohol or reasonable and/or controlled substance test if there is reasonable suspicion that the prohibitions concerning alcohol controlled substance testing has been violated. Okay, so you have supervisors who oversee drivers. People oversee a driver, and they have training that's required, and we're going to talk about the training a little bit more on what characteristics people who may be under the influence are displaying. Somebody who is drank too much, you're going to smell it, you're going to see it in their eyes, you're going to see hear it in their speech. They might be swaying a little bit because they're unsteady with drugs. They might they might be real nervous, they might be sweating, you see their eyes bouncing around, all those things like that. Those are all characteristics of people who may be under the influence of alcohol or drugs. So you as an employer have the authority to require that person, that driver, to submit to a reasonable suspicion test. So a driver gets there at work in the morning, they check in and you notice that something's not quite right. You have some training that we're going to talk about here in a little bit that says, wait a minute, I'm seeing something that indicates to me this driver is under the influence of drugs. I'm going to require you as a driver to go get a reasonable suspicion test. I'm going to wait for that result of that test before I use you, on that. So it does give you an employer a little bit of a little bit more in your in your arsenal of things used with drivers who may be displaying some of these behaviors on that. The last thing you want to do is send out a driver behind the wheel of a truck who's under the influence, and then they get involved in that crash. I can tell you one thing, you all know it better than I do because you have businesses. The liability is great, and if you have the truck, people are going to assume that you have deep pockets. You're going to get sued. There's going to be some attorney out there who is going to know that you should have done drug testing. If you've not done it, then you open yourself with liability on that. If you failed to take action when you should have, they're going to ask you why, and it's just going to go down that slippery slope where it's going to make it difficult for your company. In the case of a drug test. But that's why we give you this tool as reasonable suspicion. Return to duty. Now, this is a test that is required after you have drivers who have tested positive for drugs or alcohol. Okay, before they can come back, they have to go through a whole return to duty process, and they have to have that negative test result. That's what return to duty is. And then the last one is the follow-up testing. So say you have a driver who did test positive, let's just say marijuana. So you decided that this person you wanted to keep, as a driver for you. So you found another position that's not safety sensitive. You referred them to a substance abuse professional. They went through the evaluation, education, treatment that was prescribed. They've now had a negative return to duty test, so you can start using them as a driver. However, during the first 6 months of them being used as a driver again, you have to do at least a minimum of 6 tests. And the driver actually might be subject to testing for up to 5 years, 60 months. So the SAP will prescribe whatever the follow-up testing plan is, and you as the employer must ensure that plan is carried out on that. So you can use the driver, but there are some additional things that have to be done with follow-up testing, since we now have a individual who we have a history of controlled substances and alcohol use.
Craig, we had a question come in. If my drivers get a DOT physical one times per year, does this physical cover the substance testing?
It does not. Yeah, the medical exam is completely separate, from that. There's not a drug test or alcohol test as a component of that. So this is separate and distinct. This is something that you as the employer have to set up within your own company, or you have to, use a third-party provider and enter into an agreement with them, a contract with them to carry out drug and alcohol testing for your company. For your company, they'll help you. They'll help you do it, on that. But yeah, nothing with them. This does not, involve the medical at all. Now, sometimes we get drivers who refuse to submit. They've been selected. Let's say a driver is selected, through random testing. You're testing once per quarter, and let's say you choose the last day of the quarter to test, or let's say the last week. So you do your random selection, or you work through your consortium. They do the random selection. Your driver is selected randomly, and it is randomly. You can have a driver selected every time. On there, if you test 4 times per year, you have the same driver selected randomly all 4 times. Well, that driver is probably going to think you're picking on them, harassing them. But the bottom line is, since it's random, you have no control over that. It's a random selection. But a driver will sometimes refuse to submit, to a test on that. They get mad. They don't want to do it. Sometimes they know they'll test positive, and so they try to get around it, say, I'm just not going to go for the test. Well, if that's the case, and it does happen more often than not, I won't say more often than not, but more often than you think, where a driver refuses to submit, at that point, that now is a positive test. It's treated like a positive test, and then you as an employer cannot use that driver. It's just as if he did submit or she did submit the urine sample, it was screened and it was positive. Had the metabolites in it that were positive. A refusal is treated the same way. So, one thing you all need to have is a policy that describes the drug and alcohol testing requirements. The components of that policy are found within our regulations in Part 382 of 49 CFR. That's where the drug and alcohol testing requirements are. And within those regulations, there's a section that deals with what your policy has to contain. You need to make sure your drivers understand that, if they refuse, to submit to a required test, then that's positive and they cannot be used as a driver. And more than that, and we're going to talk about this next week at your next business session, there's a drug and alcohol clearinghouse where that positive test is going to be submitted for that driver. He is going to now be in this clearinghouse, or she is now going to be in this clearinghouse as an individual with a positive test. That means that driver cannot be used by any employer. You might determine that you want to terminate a person who tests positive, on that. So, but the information about positive tests goes into clearinghouse. So if this individual goes and applies for a job somewhere else where they're driving, trucks where CDLs are required, the clearinghouse is checked and they're going to see that there's a positive test for that driver. They're not going to hire that driver on that. So sometimes drivers get mad and they refuse to test. Don't have them do that.
And that is true for company owners as well, Craig?
Yes, it is. Yeah, yes, it is. Again, I specify employers and employees. Company owner is still an employee, of the company. So if they're subject to these rules, then that is true there. But a lot of this can be addressed in the policy and training that you might have with your employees who are subject to these rules, just to let them know, hey, it can be frustrating at times, to get selected for a test and all that, but that is part of the world that a driver lives in. These rules apply. They've applied, like I said, since 1989. And so it is part of the equation that a driver has to have done, and they need to know that in their mind. Don't let them get to the testing location where they start that whole process and then they walk out. Once they do that, the collection site person is just going to say that's a positive test. It's going to be reported. And you know, if you don't take that driver's road and continue to use the driver, then like I said in the first slide, you know, an employer is you know the one required to comply with these regulations. There's going to be a consequence. There is zero tolerance for using drivers who test positive, whether it's a positive test from the specimen or refusal. There's zero tolerance for that. There will be a significant you know, intervention. Controlled substances. So what are we testing for? We talked about, you know, who's required to. We talked about the SAP. We required about the different types of tests, some of the prohibitions. So what is being tested for controlled substances? There they are. Marijuana, cocaine, opiates, amphetamines, and phencyclidine, PCP. Those are the 5, and those are the only 5 that you can test for. So whether you're testing within your company and setting it up yourself, or whether you're going through a third party, a consortium to help you out, those are the 5 that DOT drivers are subject to. Do not test for anything else. If they are a DOT, a driver subject to the DOT regulations, those are the 5 and the only 5 that can be tested for. Okay, so you do have other tests out there that test for up to like 12. But these are the 5 that are prescribed by regulation. And the reason we stick with these 5 is we know scientifically they can be validated. There is good analysis by the labs that screen these urine specimens, and it is scientifically accurate for those 5. Some of the others, the science isn't quite there yet. So keep with these. Now, there are some metabolites from the different things, you know, opiate's a broad category. But you know, it's still opiate is being tested for. So those are the 5. So the first one listed there, we're seeing, I think 42% of all positive drug test results are coming from positive marijuana result. I don't have to tell you, not only in Virginia but across the country, you know, laws have relaxed for you know, the legal use of marijuana. You know, Virginia, you know, made some changes that went into effect July 1st and will continue to, you know, move forward for the next couple of years. But if you are a driver of a commercial motor vehicle where a CDL is required, marijuana is still prohibited. It might be legal in your state. In Virginia, I think now you can grow 4 plants, you know, that just was passed, and you can use it personally. You can't use out in public, but you could just sit in your house and use it if you grow it and do it. If you're a driver, you cannot use marijuana. If you have drivers who in other states where marijuana is legal for recreational, medicinal, you know, that's not something that your driver can partake in. So be very, very careful. Make sure your drivers understand marijuana is prohibited at this point. Will that change in the future? Who knows? But at this point, it is a prohibited, you know, drug for people who operate commercial motor vehicles. Okay. But we are seeing significant positive tests, like I said, 42 from marijuana. You know, so I do want to mention real quickly the CBD oil and CBD creams and capsules and pills and all these things out there with CBD. Understand right now that there is no scientific way to completely remove the THC, which is the chemical within marijuana that causes the psychotic effects. You know, in there is no scientific way to remove the THC from that CBD oil on that. It just cannot be done. So if you have a driver who is using CBD and they use it as pain relief, because there are some people that say it can help with pain, you know, and so if they're using it for pain relief, they're taking a chance. because scientifically that CBD oil has THC in it, which is the chemical in marijuana that is tested for. If everybody's bodies are different, metabolizes things differently, use of that CBD oil could result in a positive test for marijuana. The doctor that reviews that test and validates it and verifies it as positive, they do not know if it was CBD or marijuana, CBD oil or marijuana. They're just going to see this positive result because the THC concentration was high enough, and they're going to report it as positive. They're going to ask your driver about it. Why am I seeing a positive test result for marijuana? Your driver might explain that's because CBD, I use CBD cream on my back because my back hurts, or my knee hurts, or shoulder, or something like that. But they're going to say, well, I'm sorry, that's a positive test, because there is no way for them to distinguish between CBD oil or cream use and marijuana use. There just isn't. So, if they're taking CBD, our advice is, do not take it if you're a driver or subject to these rules. If you do take it, you're taking a chance, because if it comes up positive, you can't drive anymore, and you're going to be added to the clearinghouse, and this record is going to be there, and you're going to have to go through this whole treatment and education and follow-up program. So be very careful. But we are seeing huge increases in marijuana, and the truck driving population is right there, just like the general population. You will, contract, or if you use a third party to help you with your program, you will contract, or they will contract with a laboratory that is certified to do the analysis of these urine specimens that are collected for drug and alcohol testing. Only certain labs can do it. There are labs that are given the authority by the Department of Health and Human Services to do this kind of stuff, because there's specific knowledge, there's specific equipment that is used, for this purpose. But anyway, they'll send you summaries, and you can see the dates there. And these summaries are basically used to provide information about your program. How many tests were given, how many positive results, that kind of thing. Previous employers. So you have to make a written request, or a request to a previous employer, and you then have to ask, hey, was this driver who's applying a job for us, who worked for you, did they test positive? And so you have to get the employee's written consent to do that first as part of your application process. But you have to do that previous employer check and ask about their history. Have they tested positive? And that previous employer has to provide that to you. If you make that request and they're not providing it to you, or they're not responding to your information, get in touch with my office, and we'll follow up with that and previous employer and say, why are you not providing this information? Because it's a requirement under the law. So that applies to you too. If you have a driver that works for you, then leaves, and they go apply somewhere else, and you get that request from his potential new employer, you have to provide that information also. So you got to maintain it in writing, and then, like I said, must be immediately released, and then retain that information for 3 years. And just some additional information. Okay, so your obligation, additional obligations of as an employer. As employers, you'll provide materials explaining the regulations, requirements, and the employer's policies regarding alcohol misuse and controlled substance abuse. Again, we talked about having the policy in place. It has to have different components to it, and then you have to take those materials and make sure that people subject to these rules are aware of these different components. So they got to be aware of what types of tests are being going to be administered or could be administered, what substances are being tested for, what are the consequences for a positive test, just sort of the whole program from A to Z about your drug and alcohol testing program. That all has to be documented in your policy, and then you have to make sure that employees subject to them are aware of all these things and explain the regulations. My advice to you there is get with a good third party, get with your attorney if you don't have it, and help get their help in working through this. You don't want to be wrong on this. You want to make sure it's absolutely correct, because we do need to protect, the privacy of these individuals. You need to make sure you're in compliance. You need to make sure that you're on solid footing. If you do have to take some sort of action against a driver, that your policy would meet the test if it's challenged. So go ahead and get some outside help, and ask them, hey, can you help me get a policy in place for drug and alcohol testing on there, and they'll know what to do. We talked earlier about training. You're going to have the ability to do reasonable suspicion testing, but before that can be done, an employer that has supervisors, those people that oversee your drivers, you have to have at least 60 minutes of alcohol misuse training and 60 minutes of drug drug use training on there. So it's just a one-time training. That training is designed to give you the information you need to be able to better determine whether or not a reasonable suspicion test is required on that. Where do you get that training? Go to these third-party providers, and have them help you out. Christina, I can provide you a list that you can have as reference on some organizations that could be helpful in this area. We don't recommend any one over another. We just provide a list of organizations that we know have their ducks in a row, and that can be helpful here. And then your members can reach out to them and talk to them about their needs. So I'll get that. You and I'll follow up, and I'll get that to you. Okay, what do we see as some of our most common violations? When we're out there looking at this, we're looking at a company's compliance with these rules. We see using a driver before receiving those negative pre-employment results. We see that all the time. Companies get in a bind. They need drivers. They need them right away. They're backed up with work, and they know they have to do the drug test, so they do it. But then they use that driver right away. Don't do that. Wait till you get that negative pre-employment result and then use the driver. Like I said, usually those are turned around in 1 to 2 days. On that, it's very quick. It's very quick. So please wait. The last thing you want to do is send a driver out who is abusing alcohol and drugs, and then they get involved in some sort of crash out there. Some event happens, and it finds out that they were under the influence, or they were positive, and now that's going to point back to you on why did you use this individual. There is not going to be any good answer for you on that. It's going to be a significant, it's going to be a significant issue. You're going to go to court. You're going to lose every time on that. And I don't have to tell you, some of these results of these decisions are the civil penalties and fines and lawsuits that are being adjudicated are huge on that. So don't use that driver. Another one we have is, believe it or not, we still have a bunch of companies that do not have a program, a random program, or they don't have a program at all on there. Like I said, these have been around in one way, shape, or form since 1989. So what is that? 30 plus years. So there should really be no excuses. Everybody's got to have this who's required to have it. They should have had it all along, but we still see a lot of companies that don't. You might do random testing, but you don't meet that 50% rate. Make sure you meet that rate, 50% rate, whether it's you as just an individual company or whether it's part of a consortium, where the consortium tests at the 50% rate. But make sure that 50% rate is done. Failing to conduct post-accident testing on a driver for alcohol. That is one that's missed a lot. It says after a post-accident test, when one's required, we talked about the criteria early, then you need to do that test for alcohol immediately, but within 8 hours. For drug testing, you got to immediately, but up to 32 hours. If you don't get it done, that's a violation. Now, there are some times when you can't do it, on there. The driver, your driver might be injured on there, might have been under arrest. There might be some kind of delay where you cannot accomplish that. That's okay. We understand that. Just document those reasons. That's all we ask you to do, is just document why you couldn't do it. But at least make the attempt to do it on there. Don't miss it. Don't miss doing it. Okay. Part 40, and I bring this up is I mentioned earlier that our regulations are Part 382 of 49 CFR. Well, Part 40 of 49 CFR, 49 Code of Federal Regulations, are the prescribed procedures. These are Department of Health and Human Services procedures. This is what every collection site, every medical review officer, every employer must do when it comes to what is the actual procedures for drug and alcohol testing. So I want to go over some of these critical updates or changes on here. I want to make sure you understand that there is an Office of Drug and Alcohol Policy Compliance, and they are the one that serve as sort of the authority in all this. They're the one that works with Part 40. You can see underneath there the different modes within DOT that have drug testing requirements. FMCSA is right in the middle. So, companies subject to our rules, in FMCSA, it's Part 382. So what is Part 40? Like I said, these are, these are sort of all of the protocols that apply for drug and alcohol testing programs. Because, the way that you do things for FMCSA could be a little bit different than another agency, but Part 40 is similar. ODAPSI has a website, all sorts of information out there for you as a motor carrier employer, for your drivers, for these service agents, your blood alcohol or technicians, your saliva technicians, urine collectors, medical review officers, all that. They're the ones who have all this information out there, and for enforcement officials. So an overview of Part 40, they can get on a listserv. You can. Any provider that you use, one question you should ask them is that, are you registered with ODAPSI, the Office of Drug and Alcohol Program Compliance? Are you registered with ODAPSI on their listserv? If they look at you and sort of don't understand what you mean, you might want to continue shopping around. That is a requirement for them to be part of this, because that's how information is passed down to them. So when you're shopping around, if you use a third party, these service agents, ask that question, sort of, are you registered with ODAPSI, to get updates on Part 40. So we had some changes to the testing panel. Remember, I told you we're only testing for those 5 panels, those 5 drugs, but we've, within those, there are 4 semi-synthetic opioids that were added, that weren't included, but those are all part of the opiates. Okay. So we're not testing outside that opiate category, but we are specifically testing for hydrocodone, oxycodone, hydromorphine, oxymorphine. I think we all know why. We have significant issues in this country with people using those, those drugs, and they get addicted to them. And, I think I read something there where there was more overdose deaths in 2020 than we ever had before. So this problem is still out there. And just because people drive trucks, they're not immune from it, just like, our society's not immune from it. So those are the 4 opioids that are being specifically tested for that. So it's still the 5 panel though. So make sure that you still ask for the 5 panel, the DOT controlled substance panel, on that when you're researching, what programs you want to use, or what your current program consists of. We also added MDA, on there, which is MDA is ecstasy, but that's a type of amphetamine. So again, but specifically MDA ecstasy was added, and the other MDA was removed from the panel. Chain of custody forms, make sure you use a current chain of custody form. If you use a good provider, they'll have that. It can be done electronically too. nowadays, it doesn't just have to be done in the paper form. There's the electronic chain of custody form, but make sure you use the most current form on that one because they do change a little bit, and I'll show you. Here's an old form. It basically said DOT on there, specified agency. People were, mistakenly then leaving out, FMCSA or whatever. So really what happened, that was removed. So here's the current form. You can see where DOT was removed. There it is, and then it was removed. So there's, if you see a form that says that on it, looks like that, that's not a current form. Tell whoever, the collection people, up, we can't use that form. Make sure it looks like this. Okay. It won't say specifically DOT. It just says, what specific DOT agency is the testing authority, and you are FMCSA. Also, remember I said MDEA was removed. Old forms will have that listed, and the new forms, will have those 4, types of opiates listed, in there, as well as MDA. But MDEA, if you see one there, it's old. We're not testing for that anymore, and you cannot test for things outside of what is required for the DOT panel. And this form is what's giving the direction to everybody. So make sure your form looks like that. And again, I talked about, hey, these service agents that you use, they have to subscribe to ODAPSY's listserv. Have to do it. You can too, but they are required to. So make sure they are. And the good ones do. They understand this because that's where they're getting their information. I do want to sort of end with talking to you about something that we've seen more and more. Sometimes the MRO, who is the medical review officer, the person your driver is selected for a test, they go to the collection site, they give the specimen sealed up. The collector makes sure that specimen's valid, meets the temperature requirements, has the right quantities, all that kind of stuff, seals it all up, ships it overnight to a lab. The lab then goes ahead and does the analysis. They send that analysis to the MRO, the medical review officer, who is the doctor or the person who's looking at those results and saying, yes, I agree with them, or I have some questions. The medical review officer then is the one who reports to your company, to the person in your company who manages the program, what those results are on that. Well, sometimes the medical review officer will say, hey, it was not a positive test, but I noticed something that I have a concern about during that verification process. Maybe they noticed that this driver was taking, let's say, hydrocodone, but it did not come up in the levels that would be required to make that a positive test, but it still showed hydrocodone in that specimen on there. So they write down a safety concern. So what are you to do as a carrier? MROs are sort of taking in our opinion, are sort of, taking the easy way out. They want to put that down there just to cover themselves on that. But what do you do with it? Because it's not a positive test on that, but it's a safety concern. So now that it's documented, it's to your benefit to at least have a conversation with the driver about that safety concern on that. Maybe the driver's already told you that, hey, I take this, it's prescribed, I'm under the care of a physician, and I do take this, hydrocodone or something to help manage pain, but it's all on the up and up on that. Well, then, your conversation might be, hey, let's talk together with your doctor and see if there's another drug that maybe can be substituted where we don't have this issue on there. So it's one of those where you start to have this conversation if this safety concern is documented by the MRO on that. But again, the MRO is doing it to sort of a liability thing. They don't want to, have it come back to them if something was to happen, but it's not a positive result, but they're saying, I have a concern about it, so I want to bring it to your attention. Well, like anything else, now you are sort of on the hook to at least address it on that. So we're seeing this more and more on here. Like I said, it's sometimes it might lead to disqualification or Other times it just might say, hey, we think this could pose a significant safety risk. So, go ahead and have that conversation with your employee about it and say, hey, what's going on? It's not positive, but we have a concern that, this could be a problem that could make you disqualified, or that, poses a risk, to safety of not only yourself, but, to others on the road in our company. We need to talk about it as the employer on that. So, but again, only a verified test result from the MRO, not a safety concern, are specific actions taken, the prohibitions we talked about earlier on that. So, but I just want to mention that because we are seeing some of that. And if you get a report from the MRO that says safety concern, you'll have a little bit of an idea why. It's not a positive test. It does not meet the prohibited conduct issue, but it is something that you need to follow up on. Okay, so I mentioned before what can be done if you do see that. Have the MRO, the medical review officer who's looking at this, have them talk with the prescribing physician, see if they can do something different, change dosage, alternate dosage, or different medications, things like that. So that's the end of my presentation. I appreciate it. I know we had a couple questions, but I'll open it up. Just, if there's any final questions, please ask. And if you don't, like a lot of things, sometimes you think of the questions after the presentation's over, that's fine. Shoot them to Christina. She's got my contact info. I'll get the answers back out to her. She can call you directly or email you those directly, or you're always free to call me, directly. Just, we're FMCSA in Richmond, Virginia. Just call our office, and anyone who answers the phone will be able to help you with your with whatever question you have. But Christina, she has a direct link to me. We've talked, several times over the past few months. Excuse me. So she will help facilitate those questions and answers too, I know. But thank you for your time. And Christina, I don't know if we have any questions at this point.
We just had one, and we may have a few. I think next session for next week is actually going to dive more into that clearinghouse. But one of the questions that came up was, can the DER of the company sign up for the clearinghouse instead of having another organization entering into the system?
Well, yeah, and the answer to that question is yes. However, there are multiple entities who enter information into the clearinghouse. The DER might be one, the MRO is one, the SAP is one. There are different entities that's required to enter that. But yeah, you as the company, must be registered. And so when you register the company, you can specify the employees in the company who have the authority to access and enter and use information from the clearinghouse. So the DER is absolutely at least one person who should, because there might be an occasion where you have to enter information. You will definitely have to go in and check for information though. So you register your company, and then within that, you specify what employees of the company have access and what roles they have. So great question. And yes, you're right, Christina, we will drill in next week and specifically focus on anything and everything related to the Drug and Alcohol Clearinghouse. This was just sort of setting the stage, but the Drug and Alcohol Clearinghouse is now part, as of January last year, is now part of your program requirements. And it's been a long time coming, and it's going to be very useful. But again, there's some steps that have to be accomplished in order to get yourself registered and using that clearinghouse. So thank you for that question. Come back on the 22nd, right?
Yes, sir.
You teed it up for us on the 22nd at the same time, next Thursday. So great. Anything else?
I think that is all. Appreciate it, Craig.
All right.
Thank you very much.
Well, thank you very much. And again, I really do appreciate your all's listening to me. Drug and alcohol testing, regulations sometimes are a little bit dry. So I hope I, didn't put anybody to sleep. I had my cup of coffee here. I hope everybody else did too. But thank you again. And Christine, I really thank you. And and the Virginia Waterwell Association for the invite. Very much appreciated. And, I hope we can continue our relationship in the future and try to bring, information to your members on these different safety, safety programs that we want everybody to know about.
Absolutely. Well, thank you, Craig.
All
Thank you,
right.
everyone. Enjoy your day.
Bye-bye.
We'll see you next week.
Christina,